false. In support of the charges, the prosecution called 5 witnesses and closed this case. After the close, the defense briefly submitted that the prosecution failed to establish a prima facie case against the accused, and therefore a finding of no case was should be met, and the further submitted and briefly whether a prima facie case has been established to warrant the accused to be put on his defense. In mostly unlikely law dictionary, is sufficiently strong for his opponent to be called to answer it. Prima facie case then is one which is established by sufficient evidence and can be overcome, taken into consideration the case law and submission filed by the defense. I make a finding that a prima facie case has been established against the accused and
August. August.
So Otieno Willis, joined by dated 9th of August 2024, sworn by DC and Wanjigi, the investigating officer in this matter. The two respondents herein were arrested on 9th of August 2024 while in possession of a motor vehicle, Bigger Road, while trying to enter house number 44 along the said road. He deponed that the driver of the vehicle escaped, but the two respondents were arrested, and upon a thorough search of the vehicle, several items were recovered, which included suspected 4 explosives, hand grenades, 2 pocket phones, and 7 pocket phone chargers, 3 mobile phones, and an ID card number 2198200 belonging to Elia Karungu. The two respondents were escorted to DCI Central, that's Central Police Station, before being escorted to court later. According to the investigating officer, the two were arrested late in the evening, and there was inadequate time to conclude investigations, which investigations indicated to include the following: 1, subjecting the suspected hand grenades to bomb disposal experts for analysis, to subject the communication gadgets to the Communication Authority of Kenya to ascertain whether they are licensed and permitted to be used in Kenya. The respondents needed further to be interrogated by multi-agencies on the motive of the explosives due to the security and danger that they pose. Number 4, they needed to do an identification parade of the suspects. And number 5, that the respondents had not at the time of arrest of the own, and their fingerprints needed to be taken and forwarded to the National Registration Bureau for their proper identification. The investigating officer sought 14 days custodial orders in order to conclude the above said investigations. The application was opposed by the respondent, who indicated that no compelling reasons had been given, and that in any event, 2 days were sufficient to conduct the investigations that the state intended to conduct. The court has carefully read and considered the application, the grounds in support, and the response. The single issue for determination is whether the state has sufficiently presented compelling reasons to warrant the detention of the two respondents for a period of 14 days sought. In the case of Republic versus Danson Mugunya and another, in considering whether compelling reasons had been approved, the court held that the court has to consider, among others, the nature of the charges intended, the strength of evidence which supports the charges, the gravity of the punishment in the event of conviction, probability that the arrested persons may not surrender themselves to court for trial, likelihood of the accused or respondents interfering with witnesses, etc. The investigating officer in this case deepened that the investigations touched on influential people who are on high standing status in the society and are likely to influence the respondents, thus interfere with the investigations. However, the said persons were not mentioned. The court finds that this claim is unsubstantiated, and on its own it is not a compelling reason. In regard to the other grounds that were given, the court is convinced that from the nature of the items that were recovered during the arrest, which are suspected explosives or hand grenades, it is necessary to remand the respondents in order to establish and confirm the identity of the suspected explosives and the link with the respondents who had no identification documents at the time of arrest. The court agrees that these identities have to be confirmed before the respondents can be released, and perhaps also establish the mystery as to the reasons for possession of the items. The court therefore finds that these are compelling reasons given by the investigating officer. I, however, find that the period which was requested, which was 14 days, to be excessive for verification of the identity of the respondents and for the forensic examination of the relevant items which are already in possession of the investigators. The court will therefore allow the application for remand of the respondents for a period of 7 working days from today. So the respondents will be remanded in the meantime at Central Police Station, I believe. Is Central Police Station. The first, Your Honor. Just a minute. Just a minute. That when the state came before you, house number 54, should I get it? That house belongs to not the respondents. The respondents The owner of house number? House number.
Are but mere innocent individuals caught up in a crossfire between the state and Mr. Jimi Wanjigi. On the night of 8th, the acting Inspector General of Police issued a press statement. Well, that was after they had appeared before you, indicating they had recovered explosives in the residence of Jimi Wanjigi, not from the respondents. That is the position of the state. They've recovered explosives from the residence of Jimi Wanjigi. So the state, having taken that position, the highest police officer in the country, the IG, has publicly communicated and recovered this from Jimi Wanjigi's residence. This gentleman should now be released and let Jimi Wanjigi and the state deal. And he's ready to deal. And as he's dealing, he has since filed High Court Constitutional Petition number E396 of 2024, in which case is going to lay bare I call Constitutional Petition number E396 of 2024. Yes, E396 of 2024, in which is going to lay bare the persons who planted explosives in the said motor vehicle and at his residence. There are CCTV cameras that captured officers of the state doing what is now being alleged here. He's taken the fight on. The police officers planted explosives on that motor vehicle and at his residence. So, Your Honor, Mr. Wanjigi, having taken control of his residence and the occurrences therein, there will be no further compelling reason to detain these two gentlemen for any further investigations. Allow the innocents to get out of the fight and allow the giants to fight like giants. And they've taken ownership. And we should not waste the court's time by involving innocent third parties in what they do not know. I do believe, Your Honor, that in light of this new information, that is publicly available, and the court should take judicial notice of the IG's statement and Mr. Wanjigi's own public statement on this matter, there will be no further compelling reason to detain these two gentlemen. But if the only thing that will remain is to ascertain their identity, the court can direct that they appear before the investigating officer for their fingerprints to be taken and to report on a day so directed, which they will do. And then, Your Honor, my colleague, Mr. Ndati, will.
I also support my colleague's submissions of the application made. I also urge the court to consider that the respondents have been in custody for the last 3 days. I believe the security apparatus were doing their work, and by now they've already established the identifications of the two. So there will be no need of still holding them for a further period beyond today. Since another party has owned up on the items listed therein. I urge this court to proceed and release them forthwith with conditions that wherever is remaining for investigation be done, or they appear for any further clarification or information they need to supply. The prosecution has not said they are foreigners or illegal immigrants. Thus, they should not be held beyond today. I beseech this court to release them forthwith.
It is tried to an application as of facts cannot emanate from the bar without an affidavit confirmed as to the correctness of those facts. With all due respect to my senior, Mr. Willis Otieno, I will be asking the court to disregard all submissions made from the bar on matters of facts, as there is no one who has owned those facts. There is no affidavit placed before you. If Mr. Jimi Wanjigi has owned up to the ownership of the items which were recovered from the said motor vehicle, he should file an affidavit before this court, and the state will respond to that affidavit. Your Honor, as we are before you this morning, there is no new material which has been placed before you, apart from the submissions from the bar to warrant the court to review the orders it has given. And further, Your Honor, we note that the High Court petition E396 of 2024 has not been placed before you, either the orders or the pleadings of the said petition E396 of 2024. For the court to appreciate are attached to those pleadings, Your Honor. Your Honor, we thus urge the court to disregard the facts from the bar, to dismiss the oral application which has been made.
Argue that that's an ambush on our part. It would have been good for us to move the court through a motion if they were seeking review of the orders before you. And this court should also note that it's a court of evidence, it's a court of law that acts on evidence and the sensitive argument that the responsibles have made raising the issue of a press statement by the IG has not been placed before this court. We are unable to articulate the issues that have been mentioned one by one and verify. I've also sought to clarification from the investigating officer before this court, and it's difficult to ascertain the sentiments that have been placed before you. It will have been good practice if they document it through an affidavit so that this court can be able to verify and articulate and make its ruling accurately. With those few remarks, on behalf of the state, I oppose the application.
That time. I would not have made an oral application at that time. But the court gave today as the date of the ruling. In between, events have occurred that this court can take judicial notice of, which is allowed. The Evidence Act allows the court to take judicial notice of judicial proceedings. It is a fact there are proceedings before the High Court Constitutional Petition Division between Jimi Wanjigi and the state. They've been served. They are aware. So I'm not ambushing anybody. The DPP, the IG, the DCI are parties in petition E396 of 2024, and they have all been served. And they're aware of the orders in that court. So there's no ambush to anybody, maybe to the court itself. But this court can take judicial notice of those proceedings. The most it can do is to call for the file, which you can supply it with. So that to the extent that there are proceedings before a superior court on the question, the substance of holding these two gentlemen, I don't think only a formal application should move this court. Because all that I've said are housed in a judicial proceeding. They are not from the bar. Even what the IG said is housed. It is captured in the affidavits in petition E396. I'm just summarizing it for the court to be aware that what they are seeking is being considered elsewhere. Then secondly, Your Honor, I don't think anybody in court is disputing that these two gentlemen have now been held from Thursday. Thursday, Friday, Saturday, Sunday. Today is Monday. Already they've been held for 5 days. They've been held for 5 days without a holding order. And the court has now directed them to be held for 7 days. We are simply saying regularize it. They've eaten their 5 days already. So we should only be talking of 2 days, if at all, which we are still challenging. That whatever is remaining can be done by an order directing them to attend. The court can give strict terms. They can be accompanied by a surety or a next of kin. This is an application. This ground could not have been raised before you on Friday, on Thursdays. It could have been raised before you on that day. Why? Because at that time they had not been held for 5 days. But today they've been held for 5 days without a holding order. So it's well within the purview of this honorable court to review and take into account these circumstances. It's about justice. It's not about semantics. Give justice to the 2 gentlemen who have been held now for 5 days. There's even no holding charge until today. Not even a single holding charge has been brought before you. Just general allegations made an affidavit. Even if they said we are here, we have a holding charge. And Justice Kimaura talked about this issue of... No, I'm just summarizing. It was? But this, in the review, I'm at liberty to guide, because they said I'm raising new facts. But I'm telling the court all of these are in the law. So even the question of a holding charge is in the law. None has been brought. So the circumstances, Your Honor, this is a proper and fit case that the court should now reconsider, 5 days having passed since they were arrested, events having transpired, including judicial proceedings before a superior court, where there are orders that a non-custodial order should be issued for them if they are required by the state to appear. That's all.
Well, they leave the ruling tomorrow morning at 9.